Mr. Newman, you may proceed. The next case, I'll call it, is Brandon Moore versus State of Florida, and it is 240065. Mr. Newman.
Good morning, and may it please the court. My name is Luke Newman. I represent the appellant this morning. I'd like to reserve 4 minutes of my time for rebuttal, if I could. Your Honors, my client, Mr. Moore, comes to this court asking that his case be resolved in the same manner this court, a different panel obviously, decided about 8 years ago in a case called Falk versus State. In that case, this court, obviously a different panel, issued a decision in which it was deemed fundamental error to have a burglary jury instructed in a manner which omitted the third element of burglary, the affirmative defense of either a licensed or an invited entry. So essentially burglary, if I step back for a minute, is crossing the threshold of whatever the premises are, be it a vehicle, or which we call a conveyance in burglary law, or a structure, a home, with the intent to commit an offense therein.
Mr. Newman, let me ask you a question. Let's
Yes.
suppose you call me up, invite me over to watch the game,
Sure.
and I say to myself, I'm going to come over and I'm going to get that jar of pennies that he's got on his mantelpiece. So I come over, you invite me in. I don't actually have to commit the crime for it to be burglary, right?
You
Just the
invite me,
intent.
I'm sorry,
No,
Judge.
no. Maybe I shouldn't use first person, second person, but if I'm invited
Yes, sir.
to a place
Yes, sir.
and I say to myself, when I get there, I will be stealing something.
Yes, sir.
There's a jar of pennies that I really want. And then I knock on the door, and I'm invited in.
Yes, sir.
Have I committed burglary?
I would say no. I'd say
Why not?
because you committed a theft, but the entry.
No, I didn't steal anything. Maybe my
Oh,
my
I'm sorry.
Maybe my hypothetical's bad. My point is, if I enter a premises
Yes, sir.
with the intent to steal,
Yes,
but
sir.
I was invited to do so,
Yes, sir.
have I committed burglary?
No, sir.
Why not?
Because the entry has to be either an invitee or a licensee.
Okay. Is that one of the elements of the crime?
It's one of the elements of
My
the-
understanding is there are two elements of the crime, and then there is an affirmative defense,
Correct.
which is at issue here. But my concern is, how is it that if I'm invited to come in,
Right.
that it could ever be burglary? In other words, why is it not sort of implied in element one that there's an entry to the structure, that it is an uninvited entry?
Maybe I don't follow the question, sir. I think I agree with you, though. I think I think you agree with the first part, certainly.
It does seem like part of the problem is that the statute strongly implies, that the entry has to be a trespass of some sort.
Yeah, like if I go to Governor Square.
Correct.
And I go in a store and I steal a T-shirt.
Correct.
I've committed theft and not burglary.
I agree
right?
with that.
Okay.
I agree with that. Yeah, I don't.
Because it was a store, they welcomed me in there when they thought I was there to buy the T-shirt.
Maybe I'm saying I agree with that in
Yeah.
a hesitant nature because I'm hesitant to agree with a ton, but I tend to agree with that.
Yeah, it's just that it's listed as an affirmative defense.
I agree.
You've got these two elements in the instruction, and then
Correct.
later there's this third, which used to be called a third element, is now they've specified that, no, we mean it's an affirmative defense.
I agree with that.
But I don't see how it's an affirmative defense. It seems to be part of the crime of burglary.
But it's an affirmative defense because the Supreme Court has told us it's an affirmative defense.
And when we talk about the jury instruction, I think we can agree we're talking about 13.1, the
Yes.
burglary instruction.
That's correct.
So I don't think that was something that was briefed or argued in the appeal, but I agree if Judge Winokur, if you're saying I have problems with this being a third element, or an affirmative defense, then that's an interesting argument, but I don't think that was, I don't know if that's, maybe I can relate to maybe a feeling of hesitancy there. I mean, the 13.1 says what it says, and Fox says what it says, and so maybe.
Understood. So, along the same lines of another separate question for you, my understanding, and I'll be asking the state about the same thing, is that the state did argue that the entry was stealthy. So they argued it.
Correct.
Okay. And part of the stealthy, which I guess that infers that the entry was for the purpose of committing a crime?
Well, with the stealthy entry,
Right.
it says that if you agree that the entry was made, somebody sneaks into the
Right,
back.
right. That there's an inference that it was for the purpose of committing a crime. So part of the stealthy entry instruction is explicitly that it is without the consent of the owner. And that was instructed to the jury, and that was argued by the state.
I agree with that.
So considering that we're judging this case to whether fundamental error actually occurred, does it matter that the jury it was told to the jury, both in instructions and by the state's argument, that the entry was stealthy and that it was without consent?
So I refer to that, to what you're referring to, the part of 13.1 is the stealthy entry instruction. And so I guess what you're asking me is and I agree that it was read to the jurors, and I agree that it was part of the state's closing argument in the case. So I guess what you're asking me is, could the stealthy entry instruction have, I don't know, for lack of a better term, cured the issue with not reading the affirmative defense portion
More
of
or
the
less.
instruction?
In as much as the problem was this is fundamental error if the
Correct.
jury was unaware, because they were not instructed,
Correct.
that consent is an affirmative defense, that his consent entry would have been affirmative defense, he was deprived of his only defense, et cetera, et cetera.
Correct.
But that by reading this instruction to the jury, that the jury at least was aware that consent was part of whether or not, the consent was part of the case. That, in other words,
Oh, well,
the state argued that entry was stealthy and that it was without consent of the owner. That's in the stealthy entry instruction. So they were at least told that the state's argument is that it is without consent.
Well,
Does that make a difference?
I would say no, but part of it I agree with completely, again, hesitantly agree with what we're talking about here is that the jury was definitely told that because the defense counsel got up and said he entered with rightful authority. And so the jury was definitely told that. And the problem was that the client had gotten up and testified that he'd entered to commit a crime inside, but he was invited or licensed to enter by the occupant. And then, despite being told rightful authority, despite being told that the case is about consent, the affirmative defense, the actual language that the jurors could look at and say, oh, aha, if we believe that, look, he's not guilty of burglary, that was omitted. And so then, obviously, in ground one, I'm arguing that that's fundamental error, which I think at the end of the day, and it's on the trial court to ensure that the jurors are properly instructed, okay? And then in ground two, I'm arguing it as Falk instructed me to argue it by saying it's also ineffective assistance of counsel on the face of the record, that you can't have your client get up on the witness stand.
Doesn't Steiger say that you can't have ineffective assistance on the face of the record unless it's fundamental error?
I agree with that. And then Falk, and so my response to that is that Falk says it's both. Falk says both. So I'm not suggesting.
Well, Falk comes before Steiger, doesn't it?
Right, but I agree, but Falk says that it's both fundamental error and it's ineffective assistance of counsel on the face of the record. From this court 8 years ago.
So it's it's fundamental error if the trial was fundamentally unfair. Is that correct?
I agree with that.
So my concern is, do you think that given these matters, that the jury was, you said yourself that their argument was that he was invited.
Correct.
That there is evidence that consent of the owner was part of at least the stealthy entry part of burglary, that the jury was aware that if your client had been consent to enter, then it wasn't a burglary.
I disagree with that.
Were they aware of that?
I disagree with that.
Okay. No,
and if they were aware of that premise, if they were aware of that theme and arguments from closings and so on, then they didn't have the tools in the jury instructions provided by the judge to vote in my client's favor.
Right. So they were not properly instructed that consent was a defense.
That's ground one, yes, sir. And sir, I lay it on the trial court's feet in ground one, and I lay it on defense counsel's feet in ground two. Let me talk about in Falk, because there's this theme in my colleague's briefing from the state that, well, this may have been, that my client's testimony may have been so unbelievable, so weak, so insubstantial as to permit this court to overlook it. I want to talk about, in Falk, if the person who allegedly got battered and burglarized in Falk just drove off into the night, that's not reflected in the decision there. If the crime scene in Falk had been washed, any weapon, there wasn't a weapon, I don't believe in Falk, had been cleaned before police got a hold of it, that's not reflected in that decision there. In this case, in Mr. Moore's case, at least part of his testimony was then corroborated by a law enforcement officer who they called. My client, when he was presenting his case in chief as a defendant, relied on body-worn camera footage, which showed his injuries, which were serious, life-threatening. I think the term that was used in trial was when he was recovered from the roadway by police officers later that night. He was half dead. He'd been seriously stabbed. The other thing I'd ask this court to focus on in looking at this is if you look at the trial testimony of the alleged victim in this case, whose name was Mr. Rodriguez, he talks about my client, Mr. Moore, coming into the 18-wheeler, the cab of the 18-wheeler, and battering him, hitting him with a hammer. If you look at the verdict form, and I'll wrap up here briefly, if you look at the verdict form, the jurors found that the battery hadn't occurred. So it's not as if the jurors accepted a hook, line, and sinker everything that Mr. Rodriguez had testified to. Also in Falk, there was a jury question that I think some courts that have analyzed Falk have relied on as persuasive. In this case, there was a jury question where the jurors asked whether there's any more videos showing my client exiting specifically the cab of the 18-wheeler. So I see him into my rebuttal time. If there's no questions, I'll yield.
May it please the court, my name is Adam Wilson and I represent the state of Florida in this case. We're asking that you affirm appellant's judgment and sentence at least as to one of the burglary counts and the aggravated assault count. I believe the first issue, the question is whether the trial court's failure to request a jury instruction was fundamental error, and the Supreme Court's already answered this question. When you have a defense, the failure to request a jury instruction on that defense is not fundamental error. That was in 1993 in SOCOR.
Isn't SOCOR, SOCOR, my recollection of SOCOR is it's a voluntary intoxication defense.
That's correct.
And they didn't ask for the defense, and the Supreme Court did not reverse based on the fact that the defense was given. But if it had been given, the state would not have been required to disprove voluntary intoxication. So there's really kind of a no harm, no foul for the failure to give the instruction, whereas here, the state would have been obligated to prove that there was no consent to the entry. So I see that as significantly different than what happened in SOCOR. And plus, we've got a lot of cases that say when you deprive a defendant of their only defense in the case, that it's fundamental error.
Those cases come from Martinez, which relates to an erroneous instruction. Martinez, it was the
So it doesn't apply at all to a omission of instruction?
No, and that's the express holding of the 5th DCA in Muhammad, which I cited in the brief, is that there's two separate situations. You have the failure to give an instruction and giving an instruction that is erroneous. And it kind of makes sense that you would have different standards for those two situations, because when you give an erroneous instruction, the jury is told you can't do self-defense. In Martinez, the jury self-defense was pretty much taken off the table by the confusing jury instruction. Here, consent was never taken off the table as a defense. In fact, both parties actually agreed that consent was a defense. As you noted, the stealthy entrance instruction kind of primed the jury for the idea that the entrance had to be unlawful. The jury was also given a permission instruction that's contained within the trespass, the standard instruction for trespass. But
the state's argument in this case was not that the defendant did not have consent to enter the truck. I didn't see that anywhere in the closing argument.
Look in the state's rebuttal. in a rebuttal argument, the prosecutor says something to the effect of, the only way you're going to get reasonable doubt is if you believe his story, which is that he had consent to enter the truck.
Yeah, so basically their entire, the way they tried to prove their case was not by establishing that all of the elements of the offense were proven beyond a reasonable doubt, but that they just shouldn't believe the defense's story. The defense tells a ridiculous story, and therefore you should convict.
No, I think they...
Which may be a problem in and of itself, but that
I don't-
wasn't an issue in this case. But
No, I think
I
they're-
never heard them say he did not have consent to enter. I did not hear the prosecutor say that.
She said, she didn't, I guess she did not say the word, he did not have consent to enter. But I think the rebuttal argument clearly identifies or suggests that consent is an issue in this case. And the jury was in fact instructed that it is lawful to enter a conveyance if you have the permission of the owner. This was after the trespass instruction was given, but it wasn't explicitly listed or tied only to trespass.
So it wasn't just I understand the trespass instruction does have consent as an element.
Yeah.
You're
Or
saying
as
that
a-
it wasn't, that they were told that, but it wasn't explicitly relating to trespass?
At no point in the jury instructions does it say, this is only a defense to trespass and you don't consider this the
Well,
burglary.
my understanding is that the court was defining trespass to the jury.
The court goes through all the elements of all the burglary offenses and the lesser included offenses, and then it reads this instruction, which the jury could infer that instruction, which is broad enough to cover the entry into the truck for the burglary, would
So it
apply to
wasn't
burglary.
just part of the trespass instruction?
Huh? It is part of the trespass instruction, but the jury doesn't know that. And
Well,
in
why
fact,
should the
defense
jury
counsel,
presume that part of the trespass instruction also applies to the burglary instruction?
because the jury is told that these are the instructions on your law. Here are the elements of all these offenses. And then now I'm going to talk about an affirmative defense. And that's the trespass one, which defense counsel actually cites to the jury in her argument as justifying their consent defense. She says, look, the judge told you that consent is a defense, and she cites to the page number for this trespass instruction. So for that reason, I think the jury was actually given consent as a defense. So even if SOCOR doesn't apply, the jury was still instructed that way. Plus, the Supreme Court's decision in Knight kind of reinforces SOCOR, where the Supreme Court said that properly understood, the fundamental error test for jury instructions cannot be met where there was no error in the jury instructions for the offense of conviction, and there is no claim that the evidence at trial was insufficient to support that conviction.
But isn't that exactly what the defendant's argument is that there was an error in the instruction on the offense of conviction?
No,
and
it's a
that
defense.
They did not give the affirmative defense instruction?
No, there's no error. No, he's arguing that it's an error in the affirmative defense, which isn't an element of the offense. The Supreme Court's decided that consent is an affirmative defense to burglary. It's not an element of the offense. So I think Knight further shows that SOCOR is the governing standard here. But even if Falk was good law and controlling in this case, I would say that he can't show fundamental error in this specific case. You don't just say Falk found fundamental error, so this case is also fundamental error. The evidence of consent in this case is extremely weak, almost non-existent. The defendant's never actually invited into this truck, if you read his testimony carefully. He shows up outside, starts banging on the door, yelling. Defendant gets no response, opens the door, sticks his head in, which itself is a burglary. The victim then says, hey. At this point, the defendant's standing there, dual-wielding weapons. He's got a rifle in one hand and a hammer in the other.
Don't I remember that the defendant claimed that the victim told him, if I'm in the truck, just,
That's not it. No.
okay.
The defendant claimed that the defendant pointed to the truck. That's not an invitation. Like, the defendant claimed that he kind of asked the victim, what if you're not here in an hour, whatever it takes me to get these drugs? And the victim points to the truck. That's not an invitation to come into my truck. It's an idea, like that's probably an invitation to come knock on my truck. But even if it was an invitation, the fact that the defendant doesn't respond to the knocking and yelling suggests that any prior consent would have been withdrawn. And the victim's response to defendant's entry is that the defendant comes in, puts down the bag of cocaine, the victim turns around, grabs a knife, and chases the victim, or the defendant, out of the truck. That suggests that he wasn't, that's consistent with someone who has an armed burglar jumping into his truck and never gave consent at all. Furthermore, in this case, both parties agreed that consent was the defense. I know you disagree with that, but I think the state's argument agreed that consent was a defense. The jury was given that trespass instruction, which said that the entry into the truck was lawful if he had permission. The stealthy entrance instruction also kind of brings up consent. And then, frankly, there's no compelling demand for application of fundamental error in this case, given the strong incentive that cases like this present to stay silent when you notice an error. In Knight, this court recognized that in the context of an erroneous jury instruction, applying fundamental error every time kind of gives counsel an incentive to just sit there silently when there's an erroneous jury instruction and keep that in their hip pocket for appeal. The same thing would seem to apply when there's no instruction at all. So for those reasons, I think even if Falk's the controlling case law, you should not find fundamental error here. And because he can't show fundamental error, he can't just attach IAC on the face of the record, or IAC claim, and get reversal on that ground. IAC is a high bar. He's got to show no conceivable strategy, indisputable prejudice, and fundamental error. I don't think he can show any of those. As this court recognized in Knight, sandbagging by remaining silent with an erroneous instruction is a viable strategy, a conceivable strategy. Indisputable prejudice in this case, he can't show that without the trial judge without being able to weigh the credibility of his testimony. His story sounds
So if the
fishy.
defendant's saying that he was invited in, I'm trying to get my head around what kind of conceivable strategy would a defense counsel say, well, I'm not even gonna even ask for an instruction on that.
She asked for an instruction on the one from trespass, and then she can then argue it in this case, argue
But
consent to the
Why would it be
jury.
your strategy to not ask for it in the burglary count?
Because she can now get reversal and get another shot at this after losing this case. Because
So her strategy was to intentionally not ask for a consent instruction just in case
exactly,
she's convicted?
just like this case, this court recognized in Knight, where it suggested that there's a strategy in allowing an erroneous jury instruction to go to the jury. Seems even more likely here, where you're getting consent as a defense in a different instruction. You're getting agreement from the parties that consent is a defense. You get to argue it to the jury, and then if that doesn't work, then you get to come back again and try again with the reversible error or fundamental error. On the third issue, we agree that one of the burglary counts should be vacated, but because the defendant's a PRR, there's no need for a resentencing.
Why, with regard to the double jeopardy question, how is it that vacating one of the burglary convictions is consistent with the statute on multiple crimes, that is 775021 sub 4? It seems to me that the cases that say that, well, you can't have more than one burglary conviction if there's only one burglary and one victim,
Yeah.
they go back to a Florida Supreme Court case from 1983, Hawkins.
Yeah.
And that case was decided either right around the time of or before the statute was amended to say that any two crimes, as long as they have separate elements, offenses are separate if each offense requires proof of an element the other does not. Why would that not apply? Instead, I know that there's cases that say that, but why does that statute not apply, given that Hawkins doesn't consider the statute at all?
So the statute is basically the legislature applying the Supreme Court's Blockberger test, and I agree that both of these offenses pass that statute. The problem, in my view, is that the Supreme Court just said that these are burglary with person assaulted and burglary while armed are in fact the same offense. So that means we don't even consider Blockberger.
So even though they clearly have an element that the other does not?
Yeah, I think they're the same. At least in that view, you don't even do that test, and you just consider whether what the unit of prosecution is for. They're both, in that essence, burglaries. They're just burglaries with enhancements. And in that case, you look at the unit of prosecution for a burglary, which is the entry. So there was only one entry in this case, so you can only have one burglary. But without Hawkins, I think you would be right, and these would actually be separate offenses. And then on Erlinger, the Erlinger claim, we think that this was not preserved. I know there's a split among the districts on this decision, but we think the 3rd district has it right. And even if it's preserved, in this case, it's harmless. It's a ministerial fact, and there's no real dispute. There's never been any real dispute that he qualifies. And if there are no further questions, I would ask that you affirm one of his burglary counts and the aggravated assault. Thank you.
I'd like to address a couple of issues that my colleague brought up during his oral argument just now. First of all, the SOCOR, is that how we're pronouncing it? That logic, the logic from that case is baked into Falk itself. And so the Falk panel, when they released that decision, overtly go through the SOCOR discussion and reiterate it, and then say in that case, which is, I'd say, more factually remote than Mr. Moore's case, that it was fundamental error nonetheless. The other thing, we've talked a lot about the jury instruction 13.1 this morning. If you look at 13.1 and you where it lists the what we're calling the 3rd element or the affirmative defense, that immediately thereafter it cites to Falk in 13.1, and it says that failure to read this is fundamental error. So the idea that Falk is not good law or is not the controlling law is a new position.
So you're saying that if you fail to read this instruction, it is always fundamental error. It doesn't matter what the record says, doesn't matter what the defense, how strong the defense had been. According to this instruction, citing Falk, it is always fundamental error.
I'll read you exactly what the 13.
No, I know what it says. You don't need to read it, but do you agree with that? Or do you think that we should treat this lack of, this omission as per se fundamental error, and where we don't even have to look at the record?
Well, I mean, how I feel, how I would argue it for my client would say yes to that. But I acknowledge that there's other authority that says that this court would have to look and see if it's his sole or primary, or the defendant's sole or primary defense, and then to evaluate also whether or not that evidence that was presented that goes to that affirmative defense could be characterized as weak. Is that fair? So to be fair.
Okay, so at least you acknowledge that there's some authority that says that it's not per se fundamental error.
I agree with that. I hate to say that on my client's behalf, but I think that's the reality of Florida law. I think that's a fair statement of what the reality of Florida law says. So let me go back to this trespass instruction. I want to be clear. The state is relying this morning on this trespass instruction. That instruction was given under a heading in the jury instruction that says trespass, and also that trespass is omitted from a consideration as the secondary offense in a burglary prosecution. I want to say also that I'm a little bit relying, and I have in my briefs as well, on the trespass instruction, and that the judge caught that, the trial court caught that, and said, I need to update that. And I think that's different from saying the defense counsel asked for it. The trial court caught that, and kind of sua sponte said, I need to update that based on what we've heard from the defendant. But the same consideration, the same editing never occurred in the burglary context. And then I go back to the record itself on this entry. My client testified during his trial, and he said, that Rodriguez had told him the truck, that's where he'd be. And when I say I'm relying on pages 229 and then 243 to 44 of the trial transcript. So I think we have fundamental error on the face, and I think we have IAC on the face of the record. And for those reasons, I'm asking the court to reverse. Thank you.
Thank you both for your arguments. We have no other cases on the docket for this morning, so we are adjourned.